The webinar will begin shortly. Please remain on the line. The broadcast is now starting. All attendees are in listen-only mode.
Good evening, friends. So, welcome on Connect Easy platform once again. We are already live on YouTube, on LinkedIn, and GoToWebinar. We have already connected CA Ramesh Prabhu sir. Would like to request sir to on his camera as well. And we can see our second guest speaker, CA Abhinav Welekar sir, already on screen, and presentation is already we can see on the screen as well. A very important webinar, Intricacy in Registration of Real Estate under MahaRERA. Sir has given his mobile number as well on the screen. Would like to request everyone to note down this number for the long-term benefit. So friends, this is a very important webinar we have planned. Because of this, there are so many requests from the members regarding the same. And on what time, CA Ramesh Prabhu sir has accepted our invitation along with Abhinav Welekar sir, and we can plan this webinar today, and we can have this session. So friends, would like to request again Ramesh Prabhu sir to come on screen. Let me check his connection as well meanwhile. So, but in meanwhile, I would like to request Abhinav sir to say a few words. Yeah, sir is already joined. Sir, just connect the audio. Yeah, audio is yet to connect. So there are so many friends on LinkedIn also watching us. Ramesh Prabhu sir, we can see you, but we cannot, hear you. Yeah. So sir is joining again in a minute or two. So friends, we are very fortunate to have a speaker from Nagpur, CA Abhinav Welekar sir. Sir, it's a proud privilege for us that you have joined our today's session, and it's our pleasure. So friends, sir has joined again, and we are waiting for sir's today's address. So there is no introduction required for Ramesh Prabhu sir as well. Yes, Ramesh Prabhu sir, your audio is connected now. Please on your camera, sir. Sir, we are not able to hear you now as of now. Can you connect audio again, sir?
Only 1 minute.
Yes, sir. Yes, sir. Now it's perfect. Please continue,
Okay.
sir.
Okay. Good evening, friends. Thank you, Virag, for arranging such a wonderful session today. And of course, with me, I have CA Vivan Abhinav Welekar from Nagpur. Thank you, Abhinav, for agreeing to address intricacies in registration of a real estate project under MahaRERA. Now, as a project, real estate is one of the upcoming area, and last 10 years we have seen lots of up and down in the real estate. But with the introduction of RERA, which started somewhere in 2017, 1st May 2017, and today we are in 2024, the lot of developments have happened and more than 45,000 projects have been registered. Now the registration process initially was so simple and anybody could do sitting at their own residence. Today, because of some of the misdeeds done by some of the unscrupulous developers, which are there in every sector. So we have seen two very important incidents. One is at Kalyan and Dombivli Municipal Corporation, where nearly 3,000 odd buildings have been constructed and nearly 40 to 50 approvals have been done as a bogus approval. When I say bogus approval, that means Kalyan Dombivli Municipal Corporation did not give the approval. But however, they created the plan, they went and constructed the building, they also got the project registered. When it came to Kalyan Dombivli Municipal Corporation, to their knowledge, what they did was they investigated, and ultimately the FIR, everything was lost, and MahaRERA, who had registered the project without verifying the credentials of the approval, they of course cancelled the registration. But that does not serve the purpose. At the end of the day, as you know, the most important thing should have been that the proper verification of the document should have been done. But having done that, still the process was more or less simple. But one more incident which has shocked the entire industry is at Vasai Virar Municipal Corporation, where again 40 to 50 bogus approvals were done, buildings were constructed, and the monies were received from more than 3,500 to 4,000 people. And again, those registrations got cancelled. So having these two incidents where people started creating some unscrupulous builders or rather promoters, when they started this type of mess, the MahaRERA took a stand that all the the approval authority, that is called the developing, that is common authority, that like a planning authority, they should come out with the online portal, so that that online portal can be registered with, that can be integrated with MahaRERA. However, Mumbai Municipal Corporation, they have got an online portal. There the integration was possible. However, the other municipal corporation, there are no such online portal. And therefore, what the MahaRERA directed or requested the government that every planning authority should come out with the online portal for the approval. Of course, the government did pass a resolution. The housing department and UD department did pass that resolution. However, the preparing the portal and doing is not that easy. Therefore, till such time, MahaRERA came out with a circular or notification saying that the planning authorities now required to send the approval, whatever they have done, the approval should be coming directly to the RERA, so that they can do the registration. That means authenticity can be verified. Now, this is only related to the approval plan. That has created a lot of issues. Now, another issue which the MahaRERA has realized, the lot of dispute is happening with the related to the agreement for sale. Now, the agreement for sale, when you are uploading on MahaRERA, you put so many conditions which are contrary to the provisions of the Act. If those provisions are contrary to the Act and you have uploaded on the MahaRERA portal, it means that MahaRERA also has accepted that agreement. And therefore, MahaRERA said nothing doing. So therefore, MahaRERA started coming out with the circular saying that you need to do what is known as the agreement for sale as per the format. And if there are certain deviation, that need to be given a deviation report. With this also, the promoters, for reasons best known to them, they were not coming with the required or necessary documentation. Therefore, they also came out with a circular saying that henceforward, what should be the compulsory non-negotiable clauses in the agreement. So if these are not negotiable agreement clauses, which means that also need to be verified by the government or by the department, which means the area which the MahaRERA was not looking at or was not doing it, now they are required to verify each of the proposed agreement for sale, whether they are matching, not matching. That means there is another hassle which has been created. Going forward, you will find that MahaRERA also has come out with already a discussion document on the various amenities that you have agreed to give. Because when you are agreeing to give certain amenities, those are published in your newspaper and other paper, saying that 50 amenities, 100 amenities, 300 amenities. But whether you have put on the MahaRERA portal, have you put in the agreement? No, that is a discussion paper which is going on. There is a suggestion objection which has been called. Now, there is another discussion paper which has happened in MahaRERA is regarding the one project, one RERA. And then there is a certain guideline which is given to the bank. So the proposed directions about the bank guideline is also given, which means coming to the end, all this boils down or comes to a very critical issue, that is the MahaRERA is now required to get into the minor detail of the projects. They need to get into the minor intricacies of the project. If they are getting into the intricacies of the project, can MahaRERA, one technical department, can do all this? The answer is naturally no. If one technical department cannot do this, which means they have to expand the departments. So therefore, earlier with one technical officers, now they have added two more officers. Of course, all this will be discussed in detail by my speaker, Abhinav Welekar. But I said, let me just give you a background as to why the intricacies have gone up, why the projects are getting delayed. Now, another problem which happened in the MahaRERA registration of a project is that the lot of because of this change in the system, many people started approaching MahaRERA directly, and there was a rumor, or rather there is a information that the MahaRERA could collect that there are some sort of dealings, licensing happening, and because of that, some of the promoters are getting their registration very quickly, and therefore MahaRERA said nothing doing. We have got a registered promoters association as what? Self-regulatory organization. If we have a self-regulatory organization, naturally, all the intricacies need to be resolved through something called the officers deputed at MahaRERA by these self-regulatory organizations of the promoters, whether it is NAREDCO, Builders Association of India, or Mumbai Developers Association, CREDAI, Maharashtra, CREDAI, MCHI. So all these organizations, they have deputed their officers over there to deal with the intricacies. Now that is not over. Then one more thing. Now there are these queries also, because these are not very technical people, or they are not able to address them. Then there is an open house which has been kept. So there is a lot of disconnect. Now, if these disconnects are there and there is a lot of unrest among the people, the question now arises, can this be streamlined? Can we go with certain system wherein that can we have all the intricacies discussed today with Abhinav Welekar, who has wide experience related to the project registration. He himself is doing at Nagpur number of projects, sitting at Nagpur doing a project registration. These intricacies will certainly be discussed by Abhinav Welekar, and if there are any questions related to that, of course, he will also deal with that. And what we propose to do is, in this type of programs, we will not only educate and give some informations. Going forward, we will have some sort of online study group where the people connected can come together, interact, discuss, and take this process forward. So with this opening remarks, I now call upon Mr. Abhinav Welekar to discuss the entire intricacies, and whatever the questions are going to be asked by the participants, that also can be looked into, and we will also share the presentations through the registered participants. So thank you very much, Virag, for giving me this opportunity, and wish you all the best.
It's absolutely our pleasure, sir. You have joined and given opening remarks and keynote address. Yeah, despite of your busy schedule, we have again a physical session today in Mumbai at Juhu. Would like to request everyone that this presentation is also available in handout section. All the participants who are attending in GoToWebinar, they can download from handout section. Whoever is watching on YouTube and LinkedIn, they can come to GoToWebinar and download, or we'll share the separate link for them in a time to come, or they can connect with Ramesh Prabhu sir or Abhinav sir, and they can take from them as well. And would like to request everyone that if you are in real estate or in RERA or in this kind of specialization or a super specialization, you must connect with Ramesh Prabhu sir. Sir, would like to request you to share your number with the attendees so that they can connect with you, they can take guidance from you, and be a part of your study group as well. You are doing great job for the profession. They can also connect, and apart from real estate cooperative section also, you are doing great job, sir. You are already a chairman of MahaSeva, and so many posts you are holding as a voluntary organization as well. Would like to request Ramesh Prabhu sir to give his number and the email ID where to connect and how to connect. Over to you, Ramesh Prabhu sir.
I think I can just tell you right away.
Yes, sir.
One can note down. It is 98.
Yes,
20
20
10
10
67
67.
66.
So friends, it will be given to you in the chat box also. If you can see, you will get the Ramesh Prabhu sir number as well.
Yeah. Thank you.
So please be connect with him for the study group and the related professional material. Sir is an authority in real estate. Sir has written number of books as well, so you can gain knowledge from his book as well. So thank you, Ramesh Prabhu sir, once again, and would like to request now Abhinav sir, who is also again an expert from Nagpur, who has joined our today's session. So let me tell you, Abhinav sir, we have an audience also from entire Maharashtra, we can say, relating to this MahaRERA, not only from Mumbai but many other part of the Maharashtra as well. So would like to request you to take the proceeding ahead for our today's session, sir. Over to you, sir.
Okay, thank you so much, Virag Shah ji. First of all, thank you very much for arranging this session on the intricacies in RERA registration, as very eloquently explained by Ramesh Prabhu sir just back. Since last, I can say one and a half years, due to the issues that got raised because of the issues that were there at Kalyan Domboli or Vasai Virar regions, the whole of Maharashtra is suffering with regarding the registration of the real estate. And like all of you know, Ramesh Prabhu sir is himself such a big personality into the RERA practice. We all take due means we are all guided and supported by him. It never happens that you call him anytime during any time. Means if we have even called him late night, he will pick your call, he will answer your queries, and he is always available for the fraternity. It's never that he will not call you up. He is means if he is very busy with his schedule, then you just drop a message to him, and he will connect with you and resolve the issues that you are facing through the MahaRERA, or the issues that we get because as of means you know, I am from Nagpur, so many a times it happens that for the registrations and other aspect, it is very difficult for us to get connected to the Mumbai region. We have to travel there and the other things around. So to connect and to do everything with regarding the registration, he is a helpful authority there. We always try to resolve our issues. He helps us with regarding the complexities that are there in the RERA, and he is working there with the RERA Act in a way in which it has been drafted. He is one of the main person who had guided the government at that time. So he is an authority in himself. So thank you very much, Ramesh Prabhu sir, for introducing me for this session and giving this opportunity to me to present this, and that too in front of you. So if there are any mistakes on my part, please, yeah.
Yes, Abhinav sir. So friends, as already Abhinav sir has also told so many things about Ramesh Prabhu sir. Ramesh Prabhu sir also invited by the President House of India, Rashtrapati Bhavan, Pratibha Patil ji, as sir has visited. So there is so much of we are allowed and respect for the Ramesh Prabhu sir. So sir, all the best for all your future endeavors, professional as well as personal. We are very thankful to you, and we'll also would like to tell that we have not introduced Abhinav sir, but yes, I would like to introduce that sir is a partner in a CA firm, in a partner at APJ and Associate, and entire profile we have already uploaded in the handout section. You can download that. Sir is also hold an advisory council membership with the National Real Estate Development Council at Vidarbha. Sir, entire profile, if I can read, there is so much long. So would like in a brief, I have told that, and we have uploaded in the handout section. Please download that as well and connect with Abhinav sir as well. So over to you, Abhinav sir, once again.
Sure, sure. So I will start with the session now. So with your permission. Yeah, thank you. So as was informed to me by Virag ji and Ramesh Prabhu, we have to deal with how to register the project and to get it registered as early as possible. Because as was told by Ramesh Prabhu sir, we are facing many difficulties now with regarding the registration, as the complexities has increased. The number of documents that we have to upload has increased. So there is every probability that you face the difficulties with regarding the matching one document with the other and so many other things. So what I have tried to do is, first we will just go back to how the process of registration happens under the MahaRERA, and some important judicial rulings on that. Thereafter, we will go through the scrutiny that the MahaRERA now has established for granting the RERA registration. They have divided their departmental work into the legal, technical, and financial. So all the three aspects we will cover. What are the issues that we face, how to tackle those issues, that will be addressed in this section. And there are some complexities with the type of project that we are registering. So that part also is covered through this session. So if you see the project registration cycle, it starts with the prior registration of the project. What we mean by prior registration, we will see during the course of our discussion. The prior registration happens under section 3. The process of application happens under section 4, and under section 5, the authority either grants us the registration or they reject the registration. So while going to this main definition, that is section 3, we should know certain definitions which are very helpful while deciding whether a project is qualifying for the purpose of RERA registrations or not. So three important definitions that come are real estate project. What do you mean by real estate project? The second is how the promoter is defined, and the third is the planning area. So when you see the real estate project, it consists of the development of a building consisting of apartments, or converting an existing building or a part thereof into apartments. So this third point covers the redevelopment aspect of the construction industry. The fourth is the development of land into plots or apartments, as the case may be. So this fourth point covers all the plottable layout projects that are coming up in the Maharashtra. So if you see, the development of building will cover the new buildings and the whether they are residential or commercial. The second part will consist of whether they are means whether it's a coexisting residential and commercial, or either of. So that will be covered through the second point. The third will cover the redevelopment aspect, and the fourth will cover the layout projects. And for what they are coming up for, the purpose has to be for the selling. So if you are coming up with any of the project which is not to be sold to anyone, then there isn't any, means that won't cover under the real estate project definition. So there has to be an aspect of selling that product. Further, this definition has been expanded, which includes the common areas, the development works around this development, all the improvements and the structures thereon, and all is being rights and appurtenance belonging there. So in this definition, as you have seen, there are many terminologies that are there which has to be defined. And so the RERA Act has defined many of those, like the apartment has been defined, the building, the immovable property, all this has been defined under the RERA Act. We are not going into the detail of that because we are into the intricacies that we are facing in the registration. So we won't delve much into the detail aspect of these definitions. But we have to keep in mind that this is the definition of real estate project is very important, because this defines whether the project will get which has been used under the Act, like the real estate project and the project, they have been used interchangeably in the Act. So it might happen in some section just the project has been defined, has been specified, and in subsection the real estate project has been defined. But what it means the same. Second, the term promoter has also been defined. So what does the promoter includes? It includes a person who constructs or causes to construct an independent building or a building consisting of apartments, or convert an existing building or part thereof into the apartment. Again, what is important, for the purpose of selling all or some of the apartments to the persons and including his assignees. So this will cover the points with regarding the construction of the new building. The second part of the promoter definition is a person who develops the land into a project. Whether or not the person also construct the structure on any of the plot for the purpose of selling to other person, or all or some of the plots in the said project, whether with or without structure thereon. So this second point covers the layout table project. So a person, if he is executing a layout table project where he is just selling the plots, he is not constructing any building or any additional facilities thereon, still that will constitute that the person will be constituted as a promoter through this definition. The promoter also includes any development authority or the other public body who are constructing the buildings or who are executing any layout table project. So if MIDC comes up with the layout table project of their own, so that can be covered through this definition. Or if the MahaRERA is coming up with the layout table project or the building scheme, that will get covered through this. The main aspect this always has to be that there has to be, the purpose has to be for the selling of those plots or apartments. This will also cover the state level cooperative housing finance societies or the primary housing societies who are coming up with such apartments or layoutable project schemes. The point that we have to keep in mind while the term promoter has been defined is that it also includes the person who are called as a builder, colonizer, contractor, developer, estate developer, or any other name, or who claims to be acting as the holder of a power of attorney from the owner of the land. So all those persons who are defined under this ambit will be covered under the terminology of the promoter. Even like the term, claim has been specified here. So if anyone has claimed the title of the land on which the promoter has come up with the scheme, so whether he can also be termed as promoter, yes. If he is able to prove that he has a valid title over that land, and if that has entertained by the court and now he is claiming and that has been specified through the judgments or anything, then he can also be termed as promoter later. But through this, the liability of the promoters, this is again and such other person who construct any building or apartment for the purpose of sale. So first we have seen the real estate project, then the promoter, and the third is the planning area. What the section 3 specified is that any project which is coming under the planning area is only to be registered, and hence the planning area is also defined. So a planning area is a development area or a local planning area, or it can be termed as a regional development plan area also. It is normally defined by the local state government. They define through their gadgets what will be termed as a planning area or the development area. Normally in Maharashtra, most of the area is covered through the under the planning area. So we will come to the section 3, which is termed as a which deals with the prior registration of the real estate project. Now, if you see the section, it says the prior registration. What do you mean by prior registration? So it is the prior registration is, it is before a promoter wants to advertise, market, book, or sell his product. So it is prior registration with this respect. It's like many a times it happens that the promoter gets its he gets his project sanctioned. So many a times this question arises whether the developer or the builder can start the construction activity on this. So the answer to this is yes, because the registration aspect is concerned with the whether he wants to sell it. When he wants to sell it or advertise or market his product, then only the registration is required. Till the time he just want to construct and don't want to offer anything to the public, the registration of that real estate project is not required as per section 3(1). So no promoter shall advertise, market, book, sell, or offer for sale, or invite any person to purchase in any manner what any plot, apartment, or building, as the case may be, in any real estate project or part thereof, in any planning area, without registering the real estate project with the real estate regulatory authority. So if we read this section, it clearly says that once the promoter wants to sell, he has made his decision that now he wants to sell or advertise his product. So for that, first he will have to approach the RERA, get the RERA registration number. Once he gets the RERA registration number, then he can start the selling of his plots or apartments or buildings or any other units. Now, the first proviso to this section had talked about the ongoing projects, the projects that were pending on the date when the RERA Act came into existence. So it provided a period of 3 months for getting it registered. The second proviso talks about the whether the authority has any powers to ask any promoter to register even if his project is beyond the planning authority. So that authority was given to the RERA to do it through the second proviso of this section, where the RERA authority can ask any promoter to register even if it is not coming under the planning area. Now this section, like as we have seen, it is a charging section or the section which prescribes what has to be registered. In the same way, this section also specifies the projects which are exempt from registration. So section 3(2) specifies that if any project where the total developable land area is less than 500 square meter, or where the number of apartments proposed to be developed does not exceed 8, inclusive of all phases. So if there are phases in a project, then we have to add all such project, even though we are registering one part of that complete project. So if it means if it goes on the higher side with respect to both of the above things, then we have to register the project. For example, the total plot area in the first phase is of 300 square meter, but in totality what we are going to register is more than 500. So in that I will come under this definition and I have to register it, because it says that all the phases has to be inclusive listen. So if the in totality we are going above any of this condition, then we have to register the project. Section 32A, the proviso to that provided that the state government could reduce the limits that are specified under Section 32A. So they can reduce the limit of the plottable area or the number of apartments that has been specified. I would like to tell you that the government of Bengal has done that. There, the limit is lower to the what has been specified under the RERA Act. Now, this 32A, when came into existence, an FAQ was issued by the RERA authority, whose interpretation was that if any one of the condition is satisfied, then you have to register the projects. Due to which, even if we now read it plainly, the 32A, it says that either of the condition is satisfied, then your project was exempted. But because of that FAQ, everyone's opinion changed, and then everyone followed the fact that when both the conditions are satisfied, then only the project has to be exempted. It was challenged. We will cover that up, and how the situation is as of now will be covered in the further discussion. Now, the 32B specified all the projects where the completion certificate had been received before the prior registration of the Act. This doesn't specify any project which is getting the completion certificate after the RERA has came into existence. So this we have to keep into mind, that all the projects which are getting completion certificate after the RERA came into existence had to be registered, because that was not exempted through this section. Which were the projects which were exempted? That only those projects which had received the completion certificate before RERA came into existence. So they were only exempted. Then the redevelopment or the renovation projects where there isn't going to be any advertisement or selling of any new allotment of any plots to any outside parties. So if there is a redevelopment where the selling has to happen only to the existing owners, then such projects also there wasn't any requirement of registration, as they were exempted through Section 32C. Now, for the purpose of registration, the development, even though we are registering the project, the Act specifies that we can register it through phases, and each such phases should be considered as a single separate registration. That was allowed through the explanation to Section 3. You just keep this in mind, because there is a circular which now contradicts this. What is given in the Act is now being contradicted by an order that has been issued. So we will cover this up in later part of our discussion. Now, as I have told you, first the only projects that were exempted were through Section 32A, B, and C. That is like where the project land area was less than 500 square meter and the number of apartments were less than 8. Second, where the completion certificate has been received before the RERA came into existence. And point number 3, where the project constitutes the redevelopment or the renovation, where there isn't going to be any sale to the outside party. So only these 3 types of projects were exempt. But later on, some circulars were issued by the MahaRERA, which further granted some exemption to the projects which were not covered through the Section 3. So what are those projects? First, the FAQ that was issued, which specified that both the condition has to be satisfied with respect to the land area and the apartment. It was changed. It was due to the Gitanjali case, And so now the situation through this circular is that if either of the condition is met, like if the total land area is less than 500 and the total apartments are more than it, then we are not supposed to register the project, because we are satisfying one of the condition, and so the project will be exempted through the registration. The second part that was added was that if the promoter has received CC or OC or NA in case of the plotted development from the competitive authority any time before agreement of sale or sale deed registration. So even though the section 32B talked about the receiving the CC before the RERA came into existence, now through this circular they have specified that if we are receiving the CC or the OC, then in such cases the project is not to be registered if we are not executed any agreement of sale or sale deed before its registration. Third, all the redevelopment projects which does not involve marketing, advertising, selling or new allotment of any apartments or plots, and any other projects where the MahaRERA has specifically decided through the rulings. So all these projects now are exempt from registration under MahaRERA. Keep in mind, all these circulars are applicable only to Maharashtra. So all whatever is specified in these circulars will be applicable only in Maharashtra. Don't apply this to any other adjoining states or any other states of our country. Now, after going through section 3, we have to now address some of the questions that are raised while registration. What is to be registered under MahaRERA? Is it the registration of the promoter or is it the registration of the real estate project? And yes, the answer to this is it is the registration of the real estate project. Another question is when we have to register. What we have seen is that we have to prior register the project. So what is prior registration? Prior registration before the development work start or prior registration before the selling of the project? So as we have seen in the definition, in this example, the question that is raised here is a promoter received a building permit on 1st October, starts his construction on 15th October and wanted to advertise, market, book, sell or offer for sale by 1st of December. So what will be the date before which the promoter should obtain the RERA registration? So answer to this is before 1st of December he has to get his project registered. If he is able to get that, then he can start the selling the project from 1st of December. So can the promoter initiate the construction activity at site before obtaining the RERA registration? Yes, since the prior registration is only with respect to the selling part of the project and not with regarding the development part. The development part will be subjected to whether he has obtained all the sanctions so that he is able to start his development. Another question that arises, like again there is an ambiguity with regarding some redevelopment projects. In the example that we have taken, suppose there are 10 apartments and they get 10 apartments of the same size or of the bigger size, and the ratio either it is on the basis of the existing ratio or in the new ratio, and there are no sellable apartments to the outside customers, and the area of plot is less and the size of plot is more than 600 square meter. So what will be the case, whether such project has to be registered with the RERA? The answer to this is no, because since they are not selling the project to any third party or to any outside party, there isn't any kind of a requirement of registration of the project. Again, you will ask why, since the existing owner is getting something which is of a bigger size, so doesn't that mean that there is a sale of a bigger apartment to him? So shouldn't that be considered? No, because the person who is getting the flat under the redevelopment, he has been classified by the MahaRERA as himself as a promoter, and so there isn't any customer involved in this transaction with respect to RERA, what the RERA says, and that's why the question of promoter and allottee doesn't arise, and that's why the requirement of registration is not applicable. Another example that we can take, suppose in the same redevelopment project there are 10 apartments, the existing owner are getting 30 apartments of the bigger size, either in the existing ratio or in the new ratio, and no sales to the outside party. Again, the size of the plot is more than 600 square meter. So the answer to this again is no, we don't have to register the project since there isn't any kind of a sale to the outside party. In the same example, suppose now the size of the plot is 600 and there are 9 sellable apartments, excluding the apartment that's the original owners are getting in the redevelopment. And since now the number of apartment has gone beyond it, now this particular project has to be registered with the MahaRERA. In this case, as we are seeing that now there are 19 apartments. Suppose in the same example, only one sellable apartment is there. Even then, that project is not to be registered because the 10 apartment that the existing owners are getting, they are classified as promoter. And so that's why the sellable quantity is just one and they will be exempted. So it has to move beyond it to be required by the RERA to be registered. Again, in the same example, suppose there are 9 sellable apartments to the outside customer, but the size of the plot is less than 500 square meter. What will happen in this case? So the answer to this is it is not required to be registered due to the circular number 25 and 25A, as it specifies that if any of the condition is met, the project will be exempted from registration. Now, section 4 specifies how the application has to be made and what is the procedure for that. We will not dwell much of time in this. This is the section which specifies all these things, and there are rules, regulations, circulars, and order which specifies each document that has to be uploaded with respect to the different aspects of the registration. Now, section 42L specifies that we have to give a declaration. It is into the form B, which has to be specified by the landowner and all the person who are interested in the project, that they have to give it. They have to either do a affidavit of that, or they can notary that document on a 100 rupee stamp paper, and that has to be uploaded at the time of registration. That is specified under the section. Now, once all the documents are uploaded, all the information is fed up in the RERA manual, RERA portal. Thereafter, the scrutiny happens as under the heads legal, technical, and financial. If all the 3 departments approve your application, then you are granted the RERA registration, and it is granted under section 51A. So now the registration has to be granted within 30 days of your application. But what happens under RERA is that once you apply, suppose they have raised certain queries and have again sent the application back to you, then that this 30 days will be calculated from the time when you resubmit the application. It is never counted from the original date of application. So suppose you have applied for the registration, 5 days happens, you receive the query, you resolve the query after 10 days. So again on the 10th day, the counting of the 30 days will start. So it is always when the resubmit happens that you have to calculate these 30 days. So once you get the registration number is awarded to you, a certificate is generated, and on that basis you can start your sale. Nowadays, a QR code is also issued, which you have to specify union advertisements and all the brochures and everything. Now, if the RERA thinks that you cannot be granted registration due to any of the aspects of your application, then they can reject your application. But they have to first specify the reasons, and the reason has to be specified in writing, and they have to give you an opportunity to specify your to tell why they have to give you an opportunity of being heard, that they will listen to you, what's your contention, what you are saying, and even after that, if they are not satisfied, then only they can reject the application. They cannot outrightly reject it. They have to first give you an opportunity of being heard. Now, some of the important judicial rulings on the registration part. First is the Techno-Derived Engineers Private Limited versus Reliance Industries Infra Private Limited. Now, in this case, what happened was that a promoter was selling the industrial unit, and the MahaRERA authority said that since the term apartment is defined and it doesn't specify the industrial unit, and so such projects are out of the ambit of the RERA, and so the industrial units are not required to be registered. But keep in mind, under this case, what was defined was that the promoter was selling the industrial unit. That means he was selling something more than the plot. That means he was constructing something on those plot, and he was selling the plot along with that construction, either temporary or permanent, to his customer. So there was the industrial unit. He wasn't selling the industrial plot. Many a times happens, or many a times I get a query whether the industrial plottable unit is also exempt. So my opinion on that is no. As of now, that has not been clarified. Yes, if you are selling the industrial units where you are constructing on the industrial plot and then you are selling it to the customer, yes, through this judgment we can say that it is exempt. But again, we have to keep in mind that who has issued this order, it is the MahaRERA authority. So if it is challenged in the higher courts, it might go against the promoter also, and so we have to keep in mind this aspect. So what is exempt through this circular is the industrial units and not the industrial plots. Second, the Gitanjali Aman construction case versus the Rishikesh Paranspe. In this order, the order that 25 and 25A, the exemption order that I talked about earlier, it was because of this judgment which was passed by the MahaRERA Appellate Tribunal. What it says was that if any of the condition which was specified under section 3A, 32A, if that is complied, then the registration was not required. That means if your plot area was less than 500 or the number of units, the sellable units were less than 8, then in such cases, if any of the two condition is satisfied, then your project is exempt from registration. This judgment came in the year 2019. Thereafter, I think in the month of December 2019, circular number 25 first came, and then a clarificatory circular 25A came in the year 2023. But it reiterated the position which was specified in this judgment. Then the third case is Tupe Developers and Others versus Bansali Infotech. In this case, the MahaRERA Appellate Tribunal held that since the promoter landowner had an sharing to the extent of 20% on the total proceeds of the scheme, so he was also technically a promoter and he also has to get himself registered as a promoter. First, such promoters were to be registered as a co-promoter, but there was another judgment through which the co-promoter term was not held by the High Court. And so the RERA came up with the terminology promoter landowner, and now such promoters are getting registered under the head promoter landowner. But their liability is also similar to the liability of that of the main promoter or the developer. Then in another case, Samruddhi Developers versus Kiran Vasant Welekar and others. It was held that the promoter also includes his assignees and is required to independently comply with all the pending obligations. Suppose it happens that a promoter is there due to any suppose he passed away during the execution of this scheme. So in such cases, all his legal heirs will be liable to execute this thing, execute the scheme, and all the obligations that the original promoter had taken on the basis of the executed agreement to sell, they will have to comply with it. So this judgment said the things that it won't be the case that the liability won't pass on to the legal heirs. That is an issue, but it clearly specified this, that no, once the LRs get the rights over that property, then all the obligations that are there with respect to the original owners, which will have to be complied with, and all such assignees will have to execute it and put it to an end. Then in another case, Lavasa Corporations Unlimited, what has happened was that they had executed the lease agreement of 999 years with their customers, but it was held by the court that this agreement of lease are actually in the form of sale deed, and it won't be considered just as a normal agreement of lease of apartment. And so the court gone beyond the actual terminology of what was specified, that it is an lease agreement, but said that it constitutes sale deed, and so they will also have to register. Suppose the agreement is just with regarding the normal lease that happens, that you are renting the property to someone else, then you are regaining it back after some years, then in such cases the requirement is not there with respect to registration. But What the Lavasa did was that they tweaked the terminology of the execution of document. That was only the thing. They were actually selling the product to the end user. All the rights were transferred to the plot owners or the building apartment owners. So the court held, no, nothing doing. You will be liable to get yourself registered under the RERA Act. So these are some of the important judgments that we have to refer while registering the project. So if any of the projects is exempted or is getting covered, we have to go through this ruling. And if it comes to our conclusion that we have to either register or not register, and if the conclusion is that we have to register the project, then the process of registration has to be done on the RERA web portal. Now we will analyze all the aspects on the basis of which the RERA is scrutinizing the application that we are submitting. So the main aspect that also which was touched by Ramesh Prabhu sir, we will first go through the legal department, then we will go through the technical, and lastly the financial department. So the most important document is the title search report, which has to be issued by the advocate. It was brought by circular number 20/2021. Now the MahaRERA has a MahaRERA format for issuing the title search report by advocate. What it specifies is that it has to be addressed to the MahaRERA. The subject line has to very specifically, has to clearly specify the real estate project complete address. Complete address, I am saying. Because if that is not matching with what has been specified in your sale deed or in your sanction letter, then they won't grant you the registration. They will they will send back your application. Then again you have to change the search report and resubmit it. So the description of the property is very important. What is you specifying in the subject line and the description of the property line, it should tally. Then the advocate has to give the list of document on the basis of which he is scrutinizing your search report. All those has to be specified. All the document has to be listed by him. Then what the formats specify is that he has to give the property card, when it has been issued, by which authority it has been issued, the date of mutation entry of the owner. Then the search report has to be for a period of 30 years. The number of encumbrances on the land, who is the owner, it has to be very specifically specified who is the owner of the land. Then whether there are any comments to be specified on this, whether there are any issues regarding the ownership, that has to be given under the head qualifying comments. And thereafter they have to annex a flow of title of the said land. So the advocate has to stick with this format. If he deviates, then the RERA don't accept your search report. They will resend the application to you. Then you again have to take the search report from the advocate, which is in conformity with the format, and have to upload it. So try to stick with this format. Don't deviate on this. Then in the annexure, again, the advocate has to specify the PR card, the date of registration of the PR card, the mutation entry, the search report for 30 years, that is from which date to which date he is taking and from which sub-registrar office he has obtained this information. Here he has to specify the history of the land. So since he is specifying that he has taken, he has to give in detail the history of this land, what has happened, from whom this land was purchased, then thereafter what were the transaction that has been executed. All this stuff has to be specified in this head. Then after that, whether there is any other relevant title through this. So if anyone has any challenge this, there has been any judgment in favor of such challenge, then that also has to be specified, and whether that is now under jury, that has been again subjected to a higher court, or whether it has not been challenged by the authority or by the promoter, has to be specified. The advocate also has to give the list of all the litigation that are there and which are pending as on the date of issue of search report. Now this report has to be given on his their letterhead. This cannot means on the date of application, the max time period that you can go beyond is like the 3 months. So if your title search report is beyond the 3 months time period, then you have to again obtain a new certificate. So normally, as of now, RERA is accepting the title search report up to a period of 3 months. they can change it because it is not specified in the act or the rule, but the normal process that they are taking as of now, it is that they are accepting 3 months time period. Now, the property details that the advocate is specifying in the search report, it should be in conformity with your CAIIB, the schedule that has been defined in the CAIIB, the RERA application, the details that you have uploaded on the RERA application, the property details which are getting printed on your building permit, and the sanction map. All these four should be in conformity. If they are not, it will raise issue. The process of registration will be delayed on this aspect. Again, the plottable area has to be very specifically given in the advocate, because what happens is that by applying, we specify the plottable area in the RERA application, the portal. Now, it happens, suppose you are applying for the layout project. In layout project, it is of 2 hectares. Now, out of the 2 hectares, the 50% land goes under the road network or the open spaces or the amenities, and 50% is the plottable area. We only specify the plottable area in the application. So there is a mismatch. It might happen that the advocate might write that the total area is 2 hectares, but he should specify that the total area is 2 hectares, out of which after sanctioning, the plottable area is 1 hectare. So it should tally with what is specified in the building permit or the sanction map. Because if such query happens, comes or arise, the RERA authority raises the question, then you have to satisfy them, you have to clarify them, you have to give an additional declaration. So again, this results into the delay in getting the registration. So we should try that in the search report itself, we specify what is plottable area and what is the total area. This will clarify the position for them, and they will be able to very easily cross verify it with what is specified in the RERA application. Then in the landowner columns, the advocate has to specify who is the owner as on the date of issuance of his certificate. Again, all the encumbrances, if are there, has to be reported by the advocate in the search report, and all the legal cases. Now, with respect to the landowner, who will be the landowner? Like in the case of the joint development agreement, the landowner who is executing a joint development agreement with a builder or developer will be the owner. So the advocate will specify the name of the landowner there and not the name of the main builder or the main promoter. In the case of the redevelopment projects which are coming under MOFA, the landowner will be the society on whose land the project is coming. And in the case of redevelopment projects which are coming under the Apartment Ownership Act, in Apartment Ownership Act, what happens is that the sale deed is directly executed on the name of the individual member of the association. So they are the owner to the extent of the undivisible share of land. So in the redevelopment projects of Apartment Ownership Act, the landowner will be all the apartment owners. Suppose a redevelopment project is coming on a land where there are existing 12 owners. So all the 12 owners jointly will be the landowner. So the advocate certificate will specify that 12 numbers of persons are the joint owner of this land. Now, as we have seen, the advocate has to give us in his report, has to specify whether there are any encumbrances or any legal cases. Suppose there are encumbrances, the RERA requires that in such cases, all the legal a separate legal encumbrance certificate has to be issued, and it should be issued by the advocate. It was specified earlier, but nowadays RERA accepts such legal encumbrance on the letterhead of the promoter also. But if there are any encumbrances, what we suggest is that we should obtain this legal encumbrance certificate from the advocate. And if there are no encumbrances, in such cases, they can be issued by the promoter themselves on their letterhead. Then again, what you are specified under this certificate, the property details has to again match with the RERA application, title search report details, sale deed, building permit, and sanction map. So any document on which you are putting the project address details, it should match 100% with whatever is specified in these 5 documents. One is the portal, and another four are the documents. There shouldn't be any difference in that. So again, the legal encumbrance should not deviate with regarding to the encumbrances that are specified in the title search report, and the plot area also should be in conformity with the sanction map, building permit, title search report, and RERA application. Now, the another aspect on which there is a delay in registration is the agreement for sale. MahaRERA has specified the format. You have to follow the format. And if you are deviating with respect to the MahaRERA format, then you have to highlight all such deviating points. After highlighting all such deviating points, you also have to issue a certificate or the report, which has to be on the letterhead of the promoter. And you have to certify that I have deviated on all such specified points, and it has to be uploaded on the tab which is provided by the MahaRERA. Now, you can deviate, but there are certain clauses on which you have to go by what has been specified by the MahaRERA. So that was clarified or was detailed through order number 38. So they termed it as non-negotiable clauses. So all these clauses, like there are 6 such clauses, so you have to stick with it. You cannot change a word of these clauses. Whatever is given in the act or in the model form, you have to pick that up and you have to put it in your agreement to sell. So what are such clauses? So first is on the force majeure. Second is the time period for formation of association. Third is the time period for execution of registered conveyance deed. Then the defect liability period, and the last two are the final carpet area, what you are giving to the customer, how much you can deviate, what will happen if there is a deviation. That point also has to be written down in what has been specified in the format, and what will happen if there is termination of agreement, and what is the time period of refund. So all these points, all the 6 points have to be in total. There cannot be any change with respect to these points. If you try to change the points, you won't be able to get your registration. They will keep on resending your application, then you again have to resubmit, and now there is also order of penalty. So if they resend your application for 2 times, then they charge you the penalty of 25% of your application amount. And if again after 2 such opportunity that is given, again they charge 50% of the fees. So it is always advisable that you stick to these points, and if you stick to this, the probability of getting registration is you get it earlier. Another order recently has been issued, that is on the parking spaces. What you have to specify with respect to the parking spaces, we will cover this point under the allotment head, allotment letter. So as you have seen, there are 3 things that under legal is coming. First is the title search report, that is the format is specified. Then the agreement to sell, again the format is specified. And the third one that I think it came last year was the allotment letter. Now the authority asking us to upload the allotment letter as per the format they have given to us. The format is specified through order number 30 and 31. What it specifies is that you have to give the details of the unit that you are allotting. Then you have to give the allotment of, if you are allotting any specific garage or covered parking spaces, then the details of that has to be given. Order number 54 changed certain parts of it. Now they are asking that along with this, you have to also give the number, the type, the size, and also the place where the parking is allotted to your customer. Correct. So earlier that was not there, but through order number 54, these additional points are also to be included in allotment letter. And some of these points will also get covered under the agreement to sell. So what order number 54 specifies is that when you are allotting a covered parking space to your means the promoter is allotting any covered parking space to his client, then he has to give the number. So there has to be a map where the numbering has been done. Then which type of parking that is, whether it is a 2-wheeler parking or the 4-wheeler parking. Then what is the exact size of that parking, that also has to be specified. Then if there are number of parking places in your in the scheme, Then you also have to specify where it is going to be, whether it is a basement, basement 1, basement 2, stilled, podium, everything has to be specified. If it's a mechanized parking, whether it's uh, uh, on the ground level or on the upper area, so that also has to be specified through it, and there has to be a map of this which specifies everything. Then again, what has been added up is that now you also have to give the length, breadth, and the vertical clearance for garage and cover parking spaces. So if the cover parking space is there, you have to give three things: length, breadth, and vertical clearance. And if it is an open parking space, then it has to be length and breadth only. So you have to specify this in your agreement. So the model form of agreement that we are uploading, or the model allotment letter that we are uploading, this all details should be there. Then how the receipt of consideration is going to happen, and what will be the schedule of payment on the basis of the commitment that we are on the basis of the commitment that the promoter is complying with. Then again, there is a disclosure of information. It is very important thing, like you have to disclose through this allotment letter that the information will be available at project site and MahaRERA website. This is what is you are disclosing while you are handing the allotment letter to your client, and you cannot change this thing. It has to be there in your allotment letter. Then stage wise time schedule of completion also has to be uploaded now, and the website address of MahaRERA should be there. Again, all the encumbrance, possession date, the interest payment, how the interest will be calculated or will be paid has to be specified in your allotment letter. Now allotment letter has clarified that you can't go beyond what is specified with regarding the penal provisions. How much penal interest you can charge if there is a cancellation of allotment from the allottee. So they have specified that from if the cancellation, the letter of cancellation is received within 15 days of the allotment letter, there won't be any penalty that will be applied to him. The full amount that the promoter has received has to be repaid back to the customer. Suppose the time period is 16 to 30 days, the penalty will be 1%. If it is from 31 to 60 days, 1.5%, and 61 days, and if it is beyond 61 days, then 2%. No time period beyond this has been specified. Now, of what means, suppose they have said that it is 1%, but 1% of what? So it is 1% of the cost of the said unit. It is not with regarding what you have received, what the promoter has received. It is 1% of the cost of the said unit. For example, the unit is costing 50 lakhs rupees. So of 50 lakhs, you can charge 1%, that is 50,000 rupees. Suppose if there is a cancellation, you have issued the allotment letter just by receiving 25,000. Now you are, the promoter is eligible to receive further 25,000 from that customer, and then only he can cancel that booking, since 1% is allowed and the total cost of that unit was 50 lakhs. Now, within how much days the promoter has to refund the amount? That is the 45 days. So once this is also specified in the allotment letter, you can't change any of the clauses that are there in the allotment letter. So the refund has to be issued within 45 days. If it is not issued within 45 days from the date of the receipt of request letter, then the promoter will have to pay the interest, the penal interest, which will be at the rate of SBLR plus 2%. Some further points that has to be mentioned in the allotment letter is the execution and registration of agreement for sale, when you are going to register it, and the time schedule of completion of the project. So it is just not the complete time period, that is the final time period. When the slabs will be executed, when will the first slab will be casted, all such schedule has to be given in the annexure A. You have to specify the dates there. Then another document that is scrutinized by the legal department is the Sarsai declaration. So if there is nil encumbrances, then the promoter can issue this declaration on their letterhead. But if there are encumbrances, suppose, then you have to download the Sarsai report from the Sarsai website. But the fact is that when you are applying for the registration, this report should be within the 10 days of the date of application. That you have to keep in mind. Otherwise, again, if that is not complied with, the application will be resent back to you. So this was all about the legal aspect. Majority, 90% of the queries that are raised by the RERA department while scrutinizing your application pertains to the legal department. And the three main documents on documents are the title search report, the agreement to sell, and the allotment letter. So try to stick with what has been specified in the format. What are all the non-negotiable clauses where you can't deviate. So if you stick with it, the probability of getting your registration becomes easy. Now, with respect to the technical part, the technical department scrutinizes your form 1, form 2. I will not dwell much into it. The form B, that is the which is specified by section 42L. So it specifies that the promoter has to declare on a 100 rupees stamp paper that he will comply with the project, that he will comply with all the rules and regulations of the project. In that form B, he has to specify the complete address of the project, the name of the project, the date by which the project will be completed. So in the form B, while we apply for the registration on the portal, the date that is mentioned of the completion date and what is specified in the form B should tally. Suppose you have specified the completion date at 31st December 2026. So the same date should be there in form B. Suppose it is not there, again the application will be sent back to you by the department. So always check whether that has been done. Again, the second point is it has to be notarized or an affidavit of that document is executed. Either of is allowed. So you can either have an affidavit, you can go for the affidavit, or you can go for the notary. But either of has to be there. It just can't be on a 100 rupees stamp. Now the another thing which has been added up by the authority is that now we the promoter is required to send the building permit or the sanction letter of the layout or the building to the RERA authority on their email ID. Because as was told by Ramesh Prabhu sir earlier in his introduction, because of some issues that were raised, because of some fraud that happened with regarding the registrations, now the authority asks us that they want to check the validity, they want to check the authenticity that they are actually receiving of the sanction order and of the sanction map. So for that purpose, they are now asking that the sanctioning authority should send a mail to them and they will cross verify it, and after cross verifying it with what we have, the promoter has uploaded in the RERA application, and if it is tallying, then only they are going to allot you the RERA number. So only in the case of Mumbai that is directly linked with the MahaRERA. In all other jurisdictions, in our case in Nagpur or Pune, we have to send this mail. The process is that suppose yours is the first application from that region, then first the authority has to issue a letter that this particular sanctioning authority is specifying this particular email ID to be the email ID through which the mails will be sent to the MahaRERA. MahaRERA accept that email ID, and then any email that come from that email ID is accepted. It is tallied with what you have uploaded, and if they are tallying, then the RERA number will be allotted. But now you have to do this process. Unless and until this process is completed, RERA number is not allowed. This is again one of the major reasons for delays, because they are not able to verify this on a very fast basis. It's an issue we don't know, but it happens is that they get n number of mails on their email ID. So it becomes difficult for them to go to that particular email and check and cross verify it. Then another thing that has been added up is that the disclosure of interest in other real estate organization. This is a new declaration that has to be given. It has to be given in the case of partnership firm by all the partners, in the case of company by all the directors, and if there is any association or the society by executive body of those association and society. So everyone will have to give this disclosure whether they are having any other interest in any other project which is registered with the MahaRERA. Now, this order number 50 has come. As we have seen that the RERA allows, the explanation to section 3 allows for the phase-wise registration of the project. Now, what this circular, this order says is that the double or the multiple registration of the project on the same project land will not be allowed. Now, it has been drafted in such a way that it gives the impression that suppose there is a project where 5 buildings are going to come, but as of now I have received only the OC for the first building. I want to just register the first building as first phase, and later on I will go for the other buildings. But what it says is that I have to register the complete project. So what will happen in this case, even though there are going to be 5 buildings, I will have to register it like 1 sanction building, 4 proposed building, and in that way I have to go through the registration. The clarity on this has to be obtained, whether what's their intention on this circular. Means the process is still pending at their end, because I haven't received any specific clarification on this. And again, this declaration has to be signed and given on the later end by the promoter at the time of registration. But this is an ambiguity with the explanation of section 3 and what the RERA is asking us to do. Now the other aspect with regarding the technical department, now we are going it through if we are registering a building project. So what are the specific documents that are applicable only with regarding the building project? So if you see in the case of building projects of residential or commercial, you get the building permit or the commencement certificate. Now on this basis you have to give the declaration about commencement certificate. The date of issue of this building permit has to be given. It has to be issued on your letterhead, and it will specify the date and number of floors that are mentioned in the building permit or the commencement certificate. Then the sanction layout plan, the building sanction map. Now the another thing that is there in the building projects is that there can be a project where as of now you have registered the project with certain FSI. As of now there are certain proposed FSI which is pending. You have not got clearance for that. So you can register the project like sanctioned FSI, the proposed FSI, and the total FSI. So part of the project will get registered now, and once you get the sanction for the remaining proposed FSI, then you will again have to upload all the details and have to change the required documents on that. In the same way, proposed building can also be changed. Now with regarding the technical department, with respect to plottable layout, what differs is that there you don't get the building permit or the commencement certificate. What you get is the NA order or the tentative sanction or the final sanction. So the declaration on about the commencement certificate that the promoter has to issue, it should maintain either of these three. The date will be, if you are taking your reference as the tentative sanction, then mention the tentative sanction number and the tentative sanction date. Suppose you are taking the NA order, then mention accordingly. So you have to mention what you are uploading and what you are sharing from the email ID of that sanctioning authority. So that has to be kept in mind. Now we have till now covered the legal and the technical. Now the last part of the scrutiny is the finance part. In the finance part, the first thing that is scrutinized, that is the form 3 that is issued by the chartered accountant. Certain important aspect of that should be kept in mind is that first it has to be addressed to the promoter. The project name has to be very clearly mentioned. Second, there are some 7 tables that are there. What it means, I will just in short I will explain you. Table A is with regarding the estimates part. Table B is the actual cost incurred with respect to that estimate. Table C specifies the sold and unsold inventory along with their valuation at the ASR rate, and also if there are certain sold inventory, that the receivables from that sold inventory. Table D specifies the comparison between the remaining cost and the receivables. So at the time of first certificate, it might happen since there isn't any sale, there won't be any receivables, but there will be the remaining cost of the project. Then the table is specified, there you have to specify the designated bank account. What is designated bank account? The 70% account, where the 70% of the funds of the customer is deposited. So the promoter has to give that number to the CA. The CA has to verify that bank account where the 70% amount is going to be deposited. Many times I have seen that rather than giving the designated bank account, the CA or the promoters are giving the details of the collection account. That is not the correct way of doing it. you have to give the details of the designated bank account where the 70% of the fund is going to be deposited. Then the table F, the means of finance, how the promoter is going to finance this complete project. The details of that has to be given in table F. And if any comments or any observation has to be made by the CA, that has to be given in table G. So the important point that has to be kept in mind, that the promoter name should be clearly mentioned. Second, the project name should be mentioned. Whether if there are any sold inventory, then there will be means if the promoter has sold any of his units or the apartment before getting the project registered, then in that case, before getting the registration, he will have to pay the penalty, and then only the process of registration can be continued. So that through this certificate it is verified. Now, earlier only the chartered accountants were required to give this certificate. There wasn't any certification from the promoter. Like the promoter was said, like, no, he hasn't sold any of the units in the inventory, and on the later stage, the CA used to get the information that no, he has sent certain units or he had booked certain units before getting the RERA number. So to avoid that thing, now the promoter also have to give a disclosure of sold and book inventory on his letterhead, which was specified in circular number 29 2021 and through corrigendum. So this certificate has to be taken from the promoter first, and then only the CA should issue his certificate. Till the time we don't receive this certificate, form 1 and form 2, form 3 certificate should not be issued by the CA. Then again, now a clear declaration has to be given by the promoter that which account is his separate bank account. It has to be given on the letterhead of the promoter, and it has to be as per the order number 34 issued in the year 2022. Now, the last point regarding the finance is the financial encumbrance. Again, this encumbrance has to be given on the letterhead of the promoter. Suppose there are any financial encumbrance, that can even be given by the advocate, and that is not compulsory as of now, because they are accepting, even if there are encumbrance, they are accepting it on the letterhead of promoter. But we suggest that it should be on the letterhead of the advocate. Now, if we go on the basis of the type of projects, so what are the different things, or what are the special things that we have to keep in mind? So, with regarding the building projects, we have to keep in mind that in the building count, we have to give two things: the sanctioned and the proposed. So, if you are going for a bigger layout scheme where there are going to be n number of buildings which are going to come on that proposed project, and you have to register it as a single project, so in that case the sanctioned and the proposed, both the things has to be shared. In the same way, in the same building, if the promoter is having an opportunity to further construct, but due to the non-availability of the TDR or due to any other reason, he is restricting his sanctioning to a particular floor, and in future if he is going to go for the further floors or the sanctioning, then in such cases the FSI details should clearly mention it. That, for example, he has got the sanction for 10,000 and he is going to supposedly get further 5,000 sanction. Then in such cases the application should itself specify that in future he is going to get that 5,000 sanction, because that will clarify the things on the part of the consumer. Again, the building count, the building details requires you to give the count of the parking on the basis of whether they are covered or they are open, or how many garages are there. So this has to be given building wise. So if you are having 4 buildings, then you have to give on each building how many open spaces are there, how many closed parking spaces are there, of which type they are, and on which floor they are. So all these details you have to give at the time of registration. The further details that you have, which is not there in the case of layout project, is the task and activity. In the project, in the commercial building or the residential building project, we also have to fill the task and activity column, that how much activity has happened. Now, with respect to the layout, where there are joint holding, many times we get the proposal where the land is means the ownership is in the joint name. It is not in the name of any firm or in the company's name, or it is not in the and the client don't want to apply it as an association of person. So such projects can also be registered as a joint holding projects, and in that we have to go for the registration under the head others, and you have to specify all such members under the organization other member details. And at the time of uploading this individual member details, you also have to upload the joint sale deed that has been executed in favor of such landowners. So this specifically majorly happens in the case of the layout project. So what happens in such cases are there are multiple PAN numbers, as there are multiple owners of this such project. So 2 or 3 additional documents have to be uploaded, and what are they? First is the PAN declaration specifying that there are so many number of promoters who are holding the land jointly, and what are the PAN numbers, and the details of the PAN number has to be disclosed in that declaration. Then second is the declaration regarding non-formation, that all such joint account holders has come together, but they are not forming any separate legal entity and they want to register it as it is. So this again a declaration has to be given, and a declaration of joint account holding, that all the proceeds that are going to come is going to come in a particular joint account that they have opened. So these 3 are the additional declaration that you have to upload at the time of registrations. Now, in the case of the redevelopment projects under MOFA, what happens is that the landowner in such cases is the society. So, under the promoter landowner head, the Form B has to be issued by the society, a separate form. There will be a main promoter who will upload his Form B, and under the head promoter landowner, the Form B of the society has to be uploaded. The bank details of the society. Suppose any members want to sell his flat, so that's proceeds will come in that bank account. So bank details of the society also have to be specified and have to be uploaded. Then the development agreement of alternate accommodation with the society has to be uploaded, and the Form 3 which the CA is issuing should specify such flats which the developer or the builder is going to allot to the original owners, original members of the society. So that distinction has to be specified in the Form 3. And when you are uploading all such units on the RERA portal, there also you have to specify that these are for sale and these are not for sales, because they then tally with Form 3 and what has been uploaded under the building column on the RERA application. So this has to be kept in mind when you are going for the registration of any projects where the redevelopment is concerned and it is covering coming under the head MOFA. And suppose the redevelopment is happening under Apartment Ownership Act. Now, as I had earlier told you, here all the owners individually are the proportionate owner of that land. There is a declaration of which declaration happens, which is called a DOD, declaration of deed of declaration, that document is called as, where the individual land share of all the apartment owner is specified, and so all the apartment owners are the owners jointly. So the Form B of individual such owners has to be uploaded. Then the bank details of individual owners of such apartments have to be uploaded. Either the development agreement of alternate accommodation can be of a jointly might be executed, or individually could also be executed by the developer with such individual owners. And the same thing, Form 3, the CA should clearly see that whether the Form 3 specifies these things at the time of uploading his Form 3 on the RERA portal. So this is it with regarding the registration aspect. I will open the forum for the question and answers. I have also specified in this presentation some of the important circulars that are to be referred to at the time of registration of a project. So a list of that is given. I am not going into elaboration on that. So we can directly go to the Q&A session. Thank you. Thank you so much.
Thank you, sir. Sir, thank you so much. I would like to request Rahul Bhai to come on screen. Sir, we have a few of the questions in the question tab. If you can open. So, sir, if you can open the question tab, there are few of the question if you can take from there. So, first question is, can promoter accept advance from customer before RERA registration?
No, that is not allowed, because as we have seen under section 3.1, the promoter first has to get his project registered, then only he can advertise, market and offer for sale his units. And so there is no question that the promoter can obtain any amount from his customers, because indirectly he has offered his units for sale and he has contravened the provision of section 3.1 in that case.
Right. Second question is, for validity of once again, sir. For validity of RERA registration, suppose one project is going to be completed within 5 years. As per engineer, what are the repercussions if we apply for more than 5 years, say so for 6 or 7 years?
The RERA doesn't specify any period with regarding the completion. If you think, as per the engineer, if he is saying that the time period is 5 years, but as a promoter, if you think that the time period should be extended, so at the time of application itself, you can go for the period beyond what has been specified by the engineer. That authority the RERA has given to the promoter. So they are not restricting it to what has been specified by the engineer in this case. Promoter has that authority.
One last question. Rahul, meanwhile, you can come to a screen as well. You can on your camera and you can come on screen. Sir, one last question. For validity
Yes.
of RERA registration, suppose one project is going to be completed within 5 years, as per engineer, what are the repercussions?
We have taken this question.
Yes, sir. In case of updating the project details with the regard to change in estimate, change in partner details, what all documents are required other than form 1, 2, 2A, 3? There was one format A query raised, but I am not sure what is that. Also, the helpline does not work. How can we contact RERA authority for query raised by them?
Sir, sorry, I was not able to hear you because I lost the connection. Can you just again repeat the question, please?
Sir, it is in question tab. If you can open the question tab, there are few of the question there.
Yeah.
Meanwhile, sir, you can read that question, few of the question.
Sure,
meanwhile, for 5 to 7 minutes or around 10 minutes, we will have a Rahul Bhai's presentation, which is our growth partner from eMSME team. How eMSME platform is helping the professional, and what is the benefit of the eMSME platform. How the eMSME is really empowering the MSMEs. Would like to hear from Rahul ji, and after that we'll continue with the question answer session with Abhinav.
Sure.
So over to you, Rahul Bhai. Rahul Bhai, you would like to share the screen? Should I?
No.
You have any presentation?
My voice is audible?
Yes. Voice is audible. You can continue with the details of eMSME. So kindly introduce eMSME platform to all of us. Over to you, Rahul Bhai.
Virag Bhai, first of all, for giving this opportunity and platform. और participants जितने भी हैं सभी को very good evening. And I have no presentation to share, but yes, I will verbally explain about the platform. तो जो eMSME एक unique platform है, एक नया platform है. To understand about this platform, I would first like to share how this journey has started. So हम लोग एक इवेंट हमारी सबकी लाइफ में जो कभी हम लोग भूल नहीं सकते, कोविड जब आया था तब हमको समझ में आया कि लाइफ की अहमियत क्या है और हम लोग क्या करना चाहते हैं. तो उस टाइम पे हम सब ये चीज को रिलेट कर पाएंगे कि हम लोग हमारे काम काफी बंद थे और हम लोग को काफी समय मिला, हमारे परिवार के साथ हम लोग टाइम स्पेंड कर रहे थे, और काफी सारी चीजें उस चीज में समझ में आया कि जब हम हमारे लिए और हमारे अपनों के लिए जब हम लोग सोच रहे थे, तो ये चीज समझ के आए कि अब ऐसा कुछ करना है कि हम इस लाइफ का सही मायने में उपयोग कर सके। और उस टाइम पे ही हमारे जो प्रमोटर्स हैं, अंकुश भाई जो खुद चार्टर्ड अकाउंटेंट हैं, और हमारे बाकी प्रमोटर्स भी चार्टर्ड अकाउंटेंट हैं, तो उनको ये चीज समझ में आई कि ऐसा कुछ किया जाए जहाँ पे हम लोग रियल सेंस में एक अच्छा कंट्रीब्यूशन कर पाए, और खासकर इस देश के लिए। तो हमको उस टाइम पे समझ में आया कि जब गवर्नमेंट, करंट गवर्नमेंट है, वो आज इतना हमारी कंट्री को आगे तक लेकर के आई है, क्यों ना हम लोग उनका एज एक्सटेंडेड हैंड, ऐसा कुछ प्लेटफॉर्म बनाए जो उनकी गवर्नमेंट, जो इंडिया को जो जिस मुकाम तक लेकर के जाना है, उसमें हम लोग एक गति का काम कर सकें। तभी हमने काफी मीटिंग्स की। उस मीटिंग मंथन में हमको ये समझ में आया कि जो सबसे बड़ा चैलेंज आज की डेट में गवर्नमेंट को होता है, कि गवर्नमेंट की नीयत तो साफ है कि वो सपोर्ट करना चाहती है, और वैसे ही एमएसएमई क्योंकि बहुत बड़ा कंट्रीब्यूट करता है देश की इकोनॉमी को, तो गवर्नमेंट उसी को मद्देनजर रखते हुए काफी स्कीम्स लेकर के आती है उनको सपोर्ट करने के लिए। बट उसमें सबसे बड़ा चैलेंज हम लोगों ने देखा कि वो स्कीम काफी पहुंच नहीं पाती है। उसके दो कारण सबसे ज्यादा ये है कि एक तो अवेयरनेस नहीं है और दूसरा इंफॉर्मेशन नहीं है। तो हम लोगों ने इसके ऊपर काफी काम करना शुरू कर दिया, और 2020 अंत की बात है जब हम लोग इसके कुछ निष्कर्ष पे पहुंचे कि ऐसा प्लेटफॉर्म बनाना है कि ये जो बड़ा गैप है उसको हम लोग कवर कर पाए। तभी ईएमएसएमई काफी हमने लर्निंग्स उस प्रोसेस में लिया है, और एक ऐसा प्लेटफॉर्म बनाया जहाँ पे उद्यम नंबर के बेसिस पे एक एमएसएमई अपने उनसे रिलेटेड जितनी भी गवर्नमेंट की स्कीम है वो आइडेंटिफाई कर सकता है। तो जो अवेयरनेस है वो तो हम लोग आज भी बना ही रहे हैं, लेकिन जो इन्फॉर्मेशन उसको चाहिए थी वो हम लोग हमारे प्लेटफॉर्म के माध्यम से वो स्कीम की लिस्ट उनको पहुंचा रहे हैं, स्कीम डिस्कवरी रिपोर्ट के माध्यम से, जिसका चार्ज 1000 रुपीज मात्र हम उनसे लेते हैं। इतना ही नहीं, हम लोगों ने इस कुछ पिछले 2 से 2.5 साल में एक इकोसिस्टम भी बनाया हुआ है, जहाँ पे एमएसएमई को एक अवेयरनेस के बाद, इंफॉर्मेशन के बाद एक सहायता भी लगती है कि वो इसको अप्लाई कैसे करें। तो हमने एक एग्रीगेटर प्लेटफॉर्म बनाया हुआ है जिसको हम लोग आज की डेट में एमएसएमई बाजार बोलते हैं। एक एमएसएमई की लाइफ साइकिल में जितने भी स्टेक होल्डर्स होते हैं उन सबको हमने जोड़ने का काम किया, ताकि एमएसएमई को आज पेपर से रिलेटेड बैंकेबल बनाना है तो उनके डॉक्यूमेंट को हम लोग करेक्ट करते हैं, क्रेडिबल बनाना है। तो ये जो एमएसएमई की समस्या है कि मैं आज अपना व्यापार संभालूं या मैं स्कीम के पीछे डॉक्यूमेंटेशन के पीछे लगूं, तो हम लोगों ने उसकी लाइफ को इजी करने के लिए उसको ये अश्योरेंस दिया है कि साहब आप अपना धंधा संभालिए, और बाकी की जो आपकी एमएसएमई जो गवर्नमेंट की स्कीम से रिलेटेड जो भी समस्या है वो आप हम पे छोड़ दीजिए, बिकॉज हमने इतना अच्छा स्ट्रॉन्ग इकोसिस्टम बनाया हुआ है जिसमें आज मोर देन 15+ बैंक्स हमारे साथ जुड़े हुए हैं, मोर देन 230+ प्रोफेशनल पार्टनर्स हमसे जुड़े हुए हैं, जिसमें 90-95% चार्टर्ड अकाउंटेंट हैं। हमने ये समस्या, मैं आपको एक चीज बताना भूल गया, माफी चाहूंगा, कि जब हम लोग उस टाइम पे सोच रहे थे प्लेटफॉर्म बनाने का, तो एक बड़ा चैलेंज हमको ये भी समझ में आया, क्योंकि हमारे जो प्रमोटर्स हैं वो खुद चार्टर्ड अकाउंटेंट है। तो एक चीज रियलाइजेशन में आई कि आज जो सीए है, स्पेसिफिक हमारी जो कम्युनिटी है, उनका आज की डेट में ट्रेडिशनल प्रैक्टिस में इतना ज्यादा रेवेन्यू नहीं बचा है, तो क्यों ना हम लोग उनको ऐसा प्लेटफॉर्म दे पाए जहाँ के वो अपने लिए अच्छा रेवेन्यू बना पाए। तो ये दोनों गैप को आइडेंटिफाई करने के बाद ही हम लोगों ने प्लेटफॉर्म क्रिएट किया हुआ है। और आज मुझे बताते हुए बहुत खुशी हो रही है कि आज हमारे पास मोर देन 230+ पार्टनर्स हमसे जुड़े हुए हैं, जिसमें 90+ हमारे चार्टर्ड अकाउंटेंट भाई लोग हैं, और उनको ये अपॉर्चुनिटी मिलती है बिकॉज एक एमएसएमई का सबसे बड़ा जो एक सपोर्ट है वो उसका चार्टर्ड अकाउंटेंट है, बिकॉज उसका जो भी बही खाता है या फाइनेंस से रिलेटेड है उसको सारी कंसल्टेंसी वहीं से मिलती है। और आज जितने भी हमारे पार्टनर्स हैं उनको भी हमसे जुड़ने के बाद उनका जो पोटेंशियल था वो अनलॉक हुआ है, क्योंकि आज उनको भी जितने भी उनके क्लाइंट्स हैं उनसे हमने टैक्स भरवाया, सारी चीजें करवाई, लेकिन जब आज उनको गवर्नमेंट की स्कीम के बारे में वो लोग बताते हैं अपने क्लाइंट्स को कि मैं गवर्नमेंट से पैसा लेकर के आपको दे रहा हूँ, तो उनके क्लाइंट भी बहुत खुश होते हैं और उनको ग्रोथ में सहायता मिलती है। तो ऐसा प्लेटफॉर्म है। और इसके साथ साथ मुझे एक चीज और बतानी है कि हमने पिछले 2 सप्ताह में हमने एक प्लेटफॉर्म और लॉन्च किया है जिसका नाम है प्रो से पूछो। ये अगेन हमारे जितने भी प्रोफेशनल पार्टनर्स हैं जो हमसे जुड़े हैं उन्हीं को ही बिजनेस में बढ़ाने के लिए एक सहायता देता है, जहाँ पे वो अपने आप अपनी सर्विसेज जो अपनी स्पेशलाइजेशन है, जो अपने एक्सपर्टीज है, वो मेंशन कर देते हैं हमारे प्लेटफॉर्म पर। और एमएसएमईज जो भी कंसल्टेंसी चाहते हैं वो अपना समय ब्लॉक कर सकते हैं उनकी अवेलेबिलिटी के हिसाब से, और उस समय पे आवरली बेसिस पे या 15 मिनट्स, 20 मिनट्स, 30 मिनट्स, जितना मिनट वो कंसल्टेशन देते हैं उसका चार्ज उनको एमएसएमई से ऑनलाइन मिल जाता है। तो ये ऑनलाइन कंसल्टेशन का प्लेटफॉर्म भी हम लोगों ने एज ए वैल्यू एडेड सर्विसेज हमारे सभी पार्टनर्स को दिया हुआ है। तो आज ये इस वेबिनार में जितने भी आज पार्टनर्स आए हुए हैं एज ए पार्टिसिपेंट्स, उन सबसे मैं रिक्वेस्ट करूंगा कि आप जरूर इस चीज को एक्सप्लोर कीजिए, हमसे जुड़िए, और हम इसको डेमो देंगे आपको, इसका डेमोस्ट्रेशन आपको देंगे कि किस तरीके से आपकी वैल्यू अनलॉक हो सकती है, इसमें आपके क्लाइंट ग्रो कर सकते हैं। और जब हमारे क्लाइंट ग्रो करेंगे, हमारा देश अपना ग्रो करेगा, जिसमें हम लोग बिलीव करते हैं एमएसएमई बढ़ेगा, देश बढ़ेगा। तो बिल्कुल इससे रिलेटेड अगर किसी को कोई सवाल है तो मैं खुशी खुशी उनका जवाब देना चाहूंगा। मैं ओवर टू यू विराग भाई। आपकी आवाज नहीं आ रही विराग भाई।
पूछना चाहूंगा कि आपसे कनेक्ट होना है, राहुल भाई आपसे कनेक्ट कैसे होना है? आपका ईमेल आईडी, आपका मोबाइल नंबर, वो अगर आप दे देंगे तो दे विल डायरेक्टली कनेक्ट विथ यू एज वेल।
मैं चैट सेक्शन में डाल देता हूँ अपना मोबाइल नंबर। इज दैट ओके? मैं अभी टाइप कर देता हूँ।
यस यस, ओके ओके ओके। Abhinav sir, you can start the Q&A session, sir.
Yes. तो नेक्स्ट क्वेरी था कि इन केस ऑफ अपडेटिंग द प्रोजेक्ट डिटेल्स विथ रिगार्ड टू चेंज इन एस्टिमेट, चेंज इन पार्टनर डिटेल्स, what all documents are required other than form 1 to 2A 3? There was one format A query raised, but I am not sure what is that. That is format A is the declaration of the bank account. That is the additional requirement that you have to upload. It has to be on the letterhead of the promoter. आप वो अपलोड कर दीजिए तो हो जाएगा. The second part of that same question is that is one thing, and there are open houses every week. You have to apply for that on Tuesday. Normally the link to that starts after 11 p.m. so if you apply, then you get you can go to the open house, raise your query and get the clarification from them. तो वो एक अलग सेकेंड एस्पेक्ट है उसका. उसके बाद का जो क्वेश्चन था, विच बैंक अकाउंट शुड बी मेंशन्ड इन द रेरा एप्लीकेशन. ये रेरा डेजिग्नेटेड बैंक अकाउंट विच इज द 70% अकाउंट, जिसमें 70% पैसा जाएगा, वो वाला बैंक अकाउंट ही आपको मेंशन करना है. आपको कलेक्शन अकाउंट मेंशन नहीं करना है जिसमें 100% पैसा जाता है. In CA certificate, this is by Chetan Joshi. In CA certificate, promoter are insisting to mention collection bank account number instead of 70%. Since the bank disbursing the amount says that whenever account is reflected on the RERA portal, we will disburse in that. What should be the line of action? In that case, what I will suggest is that you mention both the accounts. You mention the account for the satisfaction of the banker, which will be the collection account, as well as in the case of the designated bank account, we should mention the 70% account. In that way, we will be able to comply with that requirement. But the requirement is always of the 70%. We can't certify the 100% account. The next question is from Vijay Bhaskar Chilka. Is there any due date to take RERA registration from the date of permission granted? No. You have to take the registration before offering your before offering your product for sale. So whenever the promoter want to sell his product, to advertise it or to market it, before that he has to get the registration of that project. Suppose he want to complete the project and at the later stage he want to register, he can do that. There isn't any restriction on that. Viragji, I have covered all the questions.
Yes, sir. Thank you so much, sir, for the wonderful deliberation. We have one question would like to take from YouTube as well. Before MahaRERA, no builder are asking EOU from customer's perspective through estate agent. So can you highlight this point, sir?
Sir, can you just repeat again? I was not able to get you.
Yeah. Before MahaRERA, There is no builder are asking for EOI from builders or a customer's perspective, from
Correct.
the buyer perspective through estate agent. So now they are, I mean, is one of the requirement. So can you highlight this point?
Actually, sir, EOI is the times it happens that the promoter has or developer has not obtained the RERA registration. In that case, EOI helps them to say that they weren't selling any product, but it was the customer who got the information of the product and had just expressed his interest in that. So that document is used in that way. Another case can be now the RERA says that you have to issue allotment letter. Correct. Even if you get 10,000 rupees booking, so everyone wants to avoid issuing the allotment letter. The promoter wants to avoid that, and for that reason, they are issuing the expression of interest letter so that they could safeguard their interest. So that can be the answer to what he has asked. There is
Yes, sir.
another question there from Chetan Joshi. Application mentioned 70% account only. Yes, absolutely right. We only have to mention the 70% account. But if you want to satisfy the requirement of the banker in that case, you are just giving the additional information. What I am saying is that the designated account should always be the 70%. In table E, you can say the additional information which will be in your comment section, and there you can give the details of your account, which is the collection account. It won't be there in the table E. It will be under the table G in that case.
Right, sir. Right. So with this, we have completed question answer session. Thank you so much, sir, for the wonderful deliberation. Thank you, Ramesh Prabhu, sir, in his absentia for the wonderful opening remarks and covered so many things in limited time. We are very thankful to you, sir. You have interacted with the attendees as well by answering all the questions. Generally, in webinar form, it's only a one way, but you have made it interactive and covered all the question as well. So thank you so much. Your presentation is also very speaking presentation, very colorful, and we can say a very with so much of clarity. One can understood directly by reading that aspect as well. So thank you once again for and thank you all the attendees who is watching live on YouTube, on GoToWebinar, and on LinkedIn as well, for making this webinar as an successful webinar, and by asking their question as an interactive webinar. So thank you so much all the attendees. Friends, we are coming up with few more webinar and a knowledge sharing session on GST refund, on charitable trust, on FNO future and options. So we will connect with us. We have sent a WhatsApp group link also in your mail, so you can connect. You can join that group and you connect with us and all other our social media handle as well. Thank you, Rahul Bhai, for the who is our growth partner. He from EMSME team for the wonderful deliberation on EMSME platform. Would like to request each and everyone here to go through social media of EMSME and particularly their website and their the Instagram handle. They are sharing small reel to update or to share the knowledge on various government scheme applicable to the MSME businesses. And also the new product, the Pro Se Pucho, you can consult yourself as an RERA expert or whatever field of your expertise in the Pro Se Pucho on EMSME website as an expert. By that you can you will get a few of the clients and you can answer them as an your expert as per available your time. So with this, we are concluding this session and we'll meet in future in a few more days. Thank you so much, all the attendees. Thank you, Abhinav sir, and thank you, Ramesh Prabhu sir. Thank you. Thank you all.
Thank you for giving this opportunity. Thank you so much.
Our pleasure, sir. Absolutely our pleasure. Friends, you can download the presentation from handout section and also the profile available at handout section. So you can download both from there. With this, we are concluding our today's session. Thank you all.